It has been a rough day on the legal front for Donald Trump because in another blow, tonight there is breaking news on the investigation into the classified documents that Trump stashed at his retirement home at Mar-a-Lago. A federal appeals court just before he went to air just ruled in favor of the Justice Department, putting a partial stay on the order from Trump-appointed Judge Aileen Cannon that would have prevented the government from using the Mar-a-Lago classified materials in their ongoing criminal investigation. Harry Litman is a former U.S. attorney for the Western District of Pennsylvania, also served as Deputy Assistant Attorney General in the Department of Justice, and he joins me now. Harry, this ruling just came out. It's a three-judge panel, we should say. Two of them, those judges appointed by Donald Trump. All three finding that for the government. Give us a rundown of what they said.
You know, it couldn't be more definitive. There's a matter-of-fact tone to it, and you read it, and really what comes through is this is so obvious. It's like waking from a nightmare. People who had looked at these other opinions by Judge Cannon tried to explain these were not in some subtle way arguably right. They were completely off the reservation. And you read these 27 pages. It's a per curiam, by the way. The three judges decided to show their unity and all be together. They almost surely have been writing it over the course of the week. So clear was it what she did was wrong. And they just set it down and rebuke everything she said. Possessory interest. We cannot discern that. You don't want to hear a court of appeals say that. We cannot discern a reason why there's a possessory interest. Grievance or irreparable injury for having to be subject of a criminal investigation like anyone else because she had given him special treatment.
Yep.
Forget about it. One after the other. Very methodical, undramatic, but when you, of course, take a step back and see how comprehensive it is, it just completely rebukes everything she did. You know, it's some restoration of faith after a truly heart-stoppingly bad set of opinions from her. And what they get, by the way, is exactly what she refused to give them in her second opinion. They now have the 100 classified documents. They've taken other things off the table. It augurs poorly for her continued mischief in the case.
Yeah, I mean, there was a not unanimous, but a near unanimous sense among people that were watching this closely in legal circles that these Cannon decisions were really wild, right? It's just untethered to sort of the basic issues. We've now seen back-to-back days in which other judges brought in to deal with the matter. Yesterday, it was Judge Dearie, who's been appointed the special master, in the hearing saying, well, what's your affirmative argument that you possess them, that they're not classified? Well, we're not going to make it. Well, then what do you want me to do, guys? And then today, a sort of similar thing from the 11th Circuit.
On one side, zero on another. Who wins? Again, not a liberal versus conservative, just judging 101 or even 1. And she had flunked it, and it's just very, very sort of straightforward, set them up, mow them down, one proposition after another.
So I want to just read one point that they made that you mentioned about this idea that the extraordinariness, right, of the stay here, in order to get the stay, right, to get them to stop, to command the government to stop investigating, which you said and others said, look, this just never happens. And every defendant, who he's not even defended yet, he's not been indicted, but everyone being investigated would love for a judge to find that there's irreparable harm in them being investigated. Here they say, no doubt the threat of prosecution can weigh heavily on the mind of someone under investigation. But without diminishing the seriousness of that burden, if the mere threat of prosecution were allowed to constitute irreparable harm, every potential defendant could point to the same harm and invoke the equitable powers of the district court. Meaning, if we let this go, like, everyone could just say, well, there's irreparable harm if they investigate me for the crimes they think I might have done.
And here's what's significant. When she said otherwise, she made a big point about Trump's special status as a former president, and people really revolted at that because it was such clear unequal justice. Their quote there just gave a regular case. She's like anyone else. Again, they could have slapped her around more harshly, but they didn't need to. It was a implicit but very strong rebuke to her idea of giving special treatment to the former president.
So the question now is where this goes. My understanding is that these are not, they can't get an en banc review because it's a stay. So as a procedural matter, the only place to go is to SCOTUS, right, to preserve Judge Cannon's ruling. And I wonder if you think they'll pursue that.
You know, it's a question of delay because it's not a fruitful idea. And right now, the linebackers are frozen. So unless the Supreme Court would reach down and undo the stay pending review, the change has come.
Right.
I don't expect that to happen. I think what really matters now, this was just give us a stay so we can go forward on this important aspect. But there's the whole huge, 1,000+ documents that are by no possible conception his. Will they now appeal? There can still be an appeal on the merits of her broader opinion, or will they say, as they told her then, we'll muddle through somehow with the rest of this unnecessary, legally wrong opinion because it doesn't harm us so much. That'll be a DOJ decision, and they're making it now. Another quick point, they did it so quickly. They knew there was injury here every day to the national security interest. And so this all worked through in just a few days.
In the 30 seconds I have left, the threat to the Trump org from Letitia James's suit today, how acute is it?
Very acute. I mean, look, it's not him in prison, but it's everything but. It's the Trump ran, which matters mightily. 200 pages, comprehensive. And I don't think they can go to trial. This is the worst day he's ever had legally.
Harry Litman, as always, a pleasure. Thank you very much.
Thank you, Chris.